I'm Ritika. Welcome to PLN Casefile, Landmark Judgment, Lalita Kumari versus Government of Uttar Pradesh, 2013. The judgment that made FIR registration mandatory in cognizable offences. What should happen when a person walks into a police station to report a serious crime? Can the police refuse to register an FIR? Can they first investigate whether the complaint is true? These questions reach the Supreme Court in one of India's most important criminal procedure cases. Today, we explore Lalita Kumari versus Government of Uttar Pradesh, the Constitution Bench judgment that clarified when an FIR must be registered and when a preliminary inquiry is permitted. The background. The case arose after allegations that the police failed to promptly register an FIR despite receiving information about the commission of a cognizable offence. This raised a larger legal question. Is the police officer legally bound to register an FIR whenever information discloses a cognizable offence, or can registration be delayed while conducting a preliminary inquiry? To settle conflicting judicial opinions, the matter was referred to a Constitution Bench of the Supreme Court. The Supreme Court's decision. The Constitution Bench held that if information clearly discloses the commission of a cognizable offence, registration of an FIR is mandatory. The police officer does not have the discretion to refuse registration simply because the allegations may later prove to be incorrect. The court explained that registration of an FIR is only the beginning of the criminal justice process. Whether the allegations are ultimately proved is a matter for investigation and, where appropriate, trial. When is a preliminary inquiry permitted? The court also recognized that in a limited category of cases, a preliminary inquiry may be conducted before registration. Examples mentioned by the court include matrimonial or family disputes, commercial transactions, medical negligence, corruption allegations, cases involving abnormal or unexplained delay in reporting. The purpose of the inquiry is not to determine guilt or innocence, but only to ascertain whether the information discloses a cognizable offence requiring registration of an FIR. If a cognizable offence is disclosed, the FIR must then be registered without unnecessary delay. Relevance under the BNSS. Although Lalita Kumari was decided under the earlier procedural law, its core principles continue to guide criminal investigations under the Bharatiya Nagarik Suraksha Sanhita 2023. The BNSS preserves the obligation of the police to register information relating to cognizable offences while providing a modern procedural framework, including electronic registration of information in appropriate cases and safeguards to improve accessibility and transparency. The constitutional commitment to prompt registration and fair investigation remains unchanged. Why this judgment still matters? Lalita Kumari continues to protect both complainants and the integrity of criminal investigations. It prevents arbitrary refusal to register genuine complaints while recognizing that limited preliminary inquiries may be appropriate in exceptional situations. The judgment reinforces a fundamental principle of criminal justice. Access to the legal process begins with the proper registration of information about a cognizable offence. Lalita Kumari remains one of the most important judgments in Indian criminal procedure. It strengthened public confidence in policing by ensuring that complaints disclosing cognizable offences cannot be ignored. Even today, its principles continue to guide fair, transparent and accountable criminal investigations. This was PLN Casefile. I'm Ritika. Thank you for watching. Join us next week as we continue exploring the landmark judgments that shape India's criminal justice system and constitutional law.